Oklahoma's lease termination framework is solidly landlord-friendly, with short notice periods and an efficient eviction process that allows property owners to act quickly when problems arise. The governing law is found in the Oklahoma Residential Landlord and Tenant Act, Title 41 of the Oklahoma Statutes, along with the state's Forcible Entry and Detainer Statute in Title 12. Let's start with no-cause termination. For month-to-month tenancies, Oklahoma requires either party to provide at least 30 days written notice before the termination date. The notice must be delivered at least 30 days before the end of the monthly rental period. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st at the latest. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required, unless the lease says otherwise. If the tenant stays beyond the lease term and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement. For week-to-week tenancies, Oklahoma requires 7 days' notice from either party, and the notice must expire at the end of a weekly rental period. Now let's get into termination for cause, and this is where Oklahoma's landlord-friendly approach really shows. For non-payment of rent, Oklahoma allows the landlord to issue a 5-day notice to pay or quit. Under Section 41-131, the landlord must provide written notice giving the tenant 5 days to pay the rent owed. If the tenant pays the full amount within those 5 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can proceed with filing a forcible entry and detainer action. Oklahoma's 5-day non-payment window is relatively short and allows landlords to move quickly when rent goes unpaid. The notice must clearly state the amount owed and the deadline for payment, and it should be delivered in a manner that can be documented: personal delivery, posting on the door, or certified mail. For lease violations other than non-payment, Oklahoma uses a different approach depending on the severity of the violation. For violations that can be corrected, the landlord must provide a written notice giving the tenant a reasonable time to cure, typically 10 to 15 days depending on the nature of the violation. The notice must identify the specific breach and warn the tenant that the rental agreement will terminate if the violation isn't corrected. For violations that materially affect health and safety, the timeline is shorter. The landlord can issue a notice giving the tenant as few as 10 days to remedy the situation before the termination takes effect. For violations that cannot be cured, or for situations where the violation is so severe that it would be unreasonable to expect the landlord to wait for a cure, Oklahoma allows immediate termination with proper notice. This includes situations involving significant property destruction, conduct that creates a serious threat to other residents, and activity that constitutes a clear violation of the lease's fundamental terms. Oklahoma has specific provisions for drug-related criminal activity. Under the state's nuisance abatement laws and the Residential Landlord and Tenant Act, landlords can pursue expedited eviction when a tenant is involved in the manufacture, distribution, or use of illegal drugs on the premises. Oklahoma courts treat drug activity on rental properties very seriously, and the eviction process for these cases is typically faster than for standard lease violations. Criminal activity more broadly also provides grounds for termination in Oklahoma. If a tenant or a member of the tenant's household engages in violent criminal activity, gang-related activity, or any criminal conduct that threatens the health or safety of other residents, the landlord can pursue eviction on an accelerated basis. One thing that sets Oklahoma apart from some states is the treatment of holdover tenants. If a tenant stays beyond the lease term or beyond the expiration of a valid notice to quit without the landlord's consent, Oklahoma law treats them as a tenant at sufferance. The landlord can immediately file a forcible entry and detainer action without providing additional notice. This makes dealing with holdover situations relatively straightforward in Oklahoma. Oklahoma's forcible entry and detainer process is efficient. Once the landlord files the action, the court issues a summons and schedules a hearing. The hearing is typically set within 5 to 10 days of filing, making Oklahoma one of the faster states for initial court proceedings. If the court rules in the landlord's favor, a writ of execution is issued, and the sheriff carries out the eviction, typically within a few days of the writ being issued. The entire process from filing to physical removal can often be completed in 2 to 3 weeks for uncontested cases. If the tenant contests the eviction, the case can take longer, but Oklahoma's court system generally moves these matters along at a reasonable pace. The tenant has the right to a hearing and can raise defenses including improper notice, habitability issues, or retaliation. If the tenant appeals, the case moves to district court for a new hearing, and the tenant may be required to post a bond or pay rent into the court to remain in possession during the appeal. On the tenant side, Oklahoma provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Oklahoma habitability video, the tenant can provide written notice and allow the landlord 14 days to make the repair. If the landlord doesn't act, the tenant can terminate. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days notice following deployment or permanent change of station orders. Oklahoma enacted the Domestic Abuse Housing Protection Act, which provides early termination rights for tenants who are victims of domestic violence. Under this law, a tenant who has obtained a valid protective order or who has documentation of domestic violence can terminate the lease by providing written notice. The tenant must provide at least 30 days' notice and include documentation such as a protective order, police report, or a statement from a qualified professional. The landlord cannot charge early termination penalties, and the tenant's liability is limited to rent through the termination date, plus any amounts owed for damages to the property. Oklahoma also provides protections for tenants who are victims of sexual assault and stalking under the same framework. The documentation and notice requirements are similar. Oklahoma strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove the tenant's belongings, or take any physical action to force a tenant out. All evictions must go through the court system. A landlord who engages in self-help eviction can be liable for actual damages, and the court may award additional penalties. Oklahoma courts consistently enforce this prohibition, and landlords who attempt self-help risk not only civil liability, but also undermining their credibility in subsequent court proceedings. One practical consideration for Oklahoma landlords: the state allows landlords and tenants to modify certain provisions of the Residential Landlord and Tenant Act by agreement, as long as the modifications don't waive fundamental rights. This means your lease can customize some aspects of the termination process, including notice periods for certain situations and cure rights for specific violations, within the bounds of what the statute allows. A well-drafted lease tailored to Oklahoma law gives you more control over the process. Oklahoma requires landlords to return the security deposit within 45 days of the tenant vacating the property. The landlord must provide an itemized statement of any deductions. If the landlord fails to comply within 45 days, they may be liable for double the amount wrongfully withheld. Interestingly, Oklahoma also requires the tenant to provide a forwarding address in writing, and if the tenant fails to do so, the landlord's obligations regarding the deposit return are relaxed. For the complete guide to Oklahoma lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.